it's an astounding victory for everyone in New York City. She has very correctly and smartly decided that the city is engaging in racial profiling. And this is it's a victory for so many hundreds of thousands of people who've been illegally stopped and frisked over the last decade.
And to those who say that this is the reason crime is down and that the number of lives that have been saved from some, what did I hear one pundit quoting today, 3,000 in a year, now down to 300 murders in a year, particularly in black and brown communities, that the number of black and brown lives saved is a result of this racial profiling? Well,
for one thing, there's no empirical evidence linking stop and frisk to crime reduction generally. Secondly, this is a tactic that this murder rate reduction has been quoted in the news. I think it's a little bit blurry. When this administration came, that's a statistic that spans the course of 15 years. It's not within the time period that we're talking about. When Mayor Bloomberg came into office, the murder rate was already down to a very small number. So they're taking credit for something that happened way before them, and they're blurring the math on this issue. In addition, the crime rates have been going down nationally for the last 2 decades, and there just isn't a link between the two.
Can you explain what Judge Scheindlin ruled in determining that stop and frisk violates the 4th and 14th Amendment, and also talk about the remedies that she's ordered?
Yes, in the 4th Amendment claim, she said that their city has a widespread practice of going out and stopping people without individualized suspicion that there is crime afoot, which is what is required by the Supreme Court law in Terry versus Ohio. In the 14th Amendment claim, she's saying that, look, many of these stops are not only based on or lack reasonable suspicion, but they're on the basis of race. The city and the New York Police Department is using race as a proxy for crime, rather than looking at what is this person doing specifically that would allow the police to stop them. They're saying, because they're black or brown in this area, we're just going to stop them to try to prevent crime, which is not constitutional. It's illegal. And then in terms of remedies, what she's done is she said that she's going to appoint a federal court monitor, which is very common in policing systemic reform cases, to oversee the day-to-day activity of reforms. And she's also said she wants a second phase of the reform where community members get to have a stake in what reforms are going to happen. And she's calling for a joint reform process that will have a facilitator that also allows the New York Police Department to have a seat at the table to say, hey, this is what we think would work, this is what we think wouldn't work. I mean, this really should be seen as an opportunity by the police department.
Who will be the court-appointed monitor?
Someone named Peter Zimroth. He's a partner at Arnold & Porter. We don't know, the Plaintiffs' Counsel we didn't have anything to do with the selection of the monitor, but we do know it sounds like he's going to be very fair-minded. He's a former corp counsel and attorney, and he's a former district attorney. So, in my mind, I would think that this is someone that the police department and the city should embrace working with, and we really hope that they will do that and decide not to appeal the judge's very well-reasoned decision.
During a news conference Monday, Police Commissioner Ray Kelly blasted the ruling and insisted New York City police officers do not engage in racial profiling.
What I find most disturbing and offensive about this decision is the notion that the NYPD engages in racial profiling. That simply is recklessly untrue. We do not engage in racial profiling. It is prohibited by law. It is prohibited by our own regulations. We train our officers that they need reasonable suspicion to make a stop. And I can assure you that race is never a reason to conduct a stop. The NYPD is the most racially and ethnically diverse police department in the world. In contrast with some societies, New York City and its police department have focused their crime-fighting efforts to protect the poorest members of our community, who are disproportionately the victims of murder and other violent crime. Disturbingly so. To that point, last year, 97% of all shooting victims were Black or Hispanic and reside in low-income neighborhoods. Public housing, in just which 5% of the city's population resides, experiences 20% of the shootings. There were more stops for suspicious activity in neighborhoods with higher crime because that's where the crime is.
That's NYPD Police Commissioner Ray Kelly speaking Monday. President Obama has indicated he may consider appointing Kelly the new Secretary of Homeland Security, to which Paul Butler, a law professor at Georgetown University and a former U.S. Department of Justice prosecutor, said Ray Kelly needs to be Homeland Security Secretary like Paula Deen needs to run the United Nations World Food Program. He wrote, Commissioner Kelly is the poster child for the most racially insensitive police practice in the United States, stop-and-frisk. During his term in office, the number of times police stopped people on the street for questioning increased from 100,000 in 2002 to about 700,000 in 2011. But Commissioner Kelly is saying that they are doing this in high-crime communities and saving lives in those communities.
Well, you know, this is something that was analyzed ad nauseum by the court. We had two statistical experts that testified multiple times in the case, and she said this is just absolutely false. She gave very little weight to this argument because in reality, the number of times that officers actually check the box on the UF 250 form that says that they're stopping someone based on a suspect description is not that high. It's between 10 and 15% depending on the year. Instead, they check this box that says high crime area. And when our statistical expert analyzed each incident from 2002 to June 2012, when that box was checked, you know, we found that when you control for all other factors, race is what is determinative. It's not actually the area and the crime rate.
What about cameras?
So the judge has ordered the city to test out and to do a study and an evaluation of body-worn cameras. This is something that has been done in, you know, a few small jurisdictions around the country and has had a favorable impact on reducing the number of complaints against police officers. Again, this is something that the police department, if it's doing its job correctly and is actually not engaging in racial profiling, would actually help and support police officers when there are complaints filed against them. You'd actually have a contemporaneous record of what's going on. It's similar in some ways to traffic cameras that are becoming standard in many large urban jurisdictions where there are complaints against police officers.
Now, the term itself, stop and frisk, can sound kind of harmless. You know, a stop and frisk, it implies a pat down. But what is the reality of this practice that you see from talking to your clients?
I mean, the reality is, that's a great question because I think a lot of people think of it as a very just like blasé, it's just a frisk, it's just a pat down. What we heard in the trial was testimony from 12 people who said, look, this is humiliating, this is degrading, this is something that no one should have to go through, and even worse, it's something that is that entire generation of Black and brown people is becoming desensitized to. And we're talking about something that is physically invasive and degrading. You know, this is an officer that's saying, "Hey, put your hands against the wall," and aggressively putting their hands over their bodies, or down their waist, down their pant legs, both sides. And one of our plaintiffs, or one of our witnesses, even testified about, being grabbed in the groin area, and he felt on his 18th birthday, and he just felt that this was so humiliating. He filed a complaint, and you know, at that young age, to even to bring that forward and to make that kind of claim, and then feel that the officer was not held accountable. I mean, it really has a lasting detrimental impact on the relationship between the police and the community.
So what happens from here? The city says they'll appeal.
The city says they'll appeal. As I said earlier, I really hope that after they carefully consider the decision, they'll decide not to. However, you know, they may appeal. apparently Michael Cardozo said that they're considering when they can appeal. It's not clear if they can appeal yet. And they will likely file a stay, which is something asking for the court, they'll ask Judge Scheindlin to stay her injunction so that they don't have to do anything right now.